national issues by bringing in love. I was reading a response that has been filed before the honorable members of the Select Committee, and the main defense appears to be that what is before Parliament of Kenya, National Parliament of Kenya, dealing with the grave national issues, is because of my ex-wife. My ex-wife is the one who is bringing trouble. Unbelievable. Unbelievable that you should trivialize a matter of national, international issue and say it's my ex-wife who's doing this. Let us not invoke mundane, primitive concepts of love, of tribalism, of religion. Those no longer make sense in Kenyan context at all. We are all nationals of Kenya. We are all concerned about Kenya. We want Kenya to move on and become like Singapore, become like Korea, the way those people came and lived in this country, studying the way that we are doing things, and they were very much impressed. They have developed more than ourselves. And we have gone backwards because of corruption, portfolio corruption in the country. It is only Parliament that can save us. If it is marriage, we intermarry. I had a Kikuyu wife. Unfortunately, she died. I loved her. When she died, I cried. She was a good woman, Joyce. She became a judge. My son, the firstborn, unfortunately, is dead. He was married to a Meru lady. I never objected. She was a good daughter-in-law. So these things of invoking tribalism, invoking love, and so on, must cease. And you as Parliament, you must rise to the occasion and tell people like Linturi, go, we have had enough of you. Thank you.
Thank you, Senior Counsel. Honorable Wamboka, please provide us with the list of your witnesses so that the members can know the individuals who will be representing you. As
last one on the list.
please provide the list to our secretariat and we will proceed.
We have supplied a bundle, this bundle that is supplied to the whole committee, part of the committee. The list is at page 193 of the bundle. It consists of a list of documents and witnesses.
Thank you.
Yes.
I take this opportunity now to welcome CS.
Thank you very much, Honorable Chair and members. My name is Mithika Linturi'S. I'll be making the opening statement on behalf of the Cabinet Secretary. I'll do 30 minutes, and my colleague, Mr. Mawira, will do 10 minutes. Unfortunately, sometimes my eyes is challenged, so I don't mind, Chair, if you interrupt me at the 30-minute mark, so that Mawira, because I might not be able to see the screen as clearly as it should. Honorable Chair and members, we have been wondering, and we have read and read this motion with a lot of keenness, and we've been left wondering why we are here. Of course, we know the simple answer, is that there is a motion before the House, and it was sent to this committee to investigate. Here is why we've been wondering, Honorable Chair, why we're here. The motion before you has 3 allegations. Allegation number 1 relates to the Constitution. Allegation number 2 relates to alleged crimes at the national law, which unfortunately the evidence given is evidence that arises from personal cases about love and affection. And unfortunately, to the extent, unless that allegation is dropped, allegation number 2, we have to confront it. And if, as I will show you shortly, it is about love and affection and personal matters, then unfortunately we must confront it, even though it is sad that a committee like this would have its time being spent on such a matter. And number 3, we are here because it is alleged that the Honorable Linturi is guilty of gross misconduct. Honorable Chair and members, for you to uphold this motion, you must be satisfied on the material that will be presented by both sides that the Honorable Linturi has committed a gross violation of the Constitution, number 1. 2, that there are serious reasons, not frivolous reasons, not reasons tied to unrequited love and affection, that warrant a belief he has committed a serious crime under national law. And of course, you must be persuaded that there is an act or omission, a specific act or omission on the part of the Honorable Linturi that constitutes any of these 3 things, either a gross violation of the Constitution or a crime under national law or gross misconduct. We have, in our response, Honorable Chair and members, that we filed yesterday, presented before you a decision of the Supreme Court under Annexure number 7 in our BADO, specifically on pages 132 and page 190 to be more precise, on what the Apex Land Court in our land has said is the threshold that must be satisfied when you're seeking to remove a state officer from office for allegations such as the one before you. And when you read it, I will invite you to note that 1, there must be a specific act, a specific omission attributable to the Cabinet Secretary that is in question. I use the word specific, not nebulous and broad and vague and nebulous and broad and vague and amorphous. Number 2, that act or omission which you must be satisfied has been committed, there must be a nexus between it and the Cabinet Secretary, which is to say, contrary to some of the submissions I've had, it is not a matter where you say, some guy must be hanged for this, somebody must be crucified for this. No. The Supreme Court has said there must be a nexus, a link between the Cabinet Secretary and the matter in question. I want you to note, it also has certain evidential thresholds. It is very easy to allege things. Proving things is where things become a bit more serious. And the Supreme Court has set the standard in flyer number 7 of our BADO. The linchpin of this case before you, Honorable Chair and members, is, quote unquote, that the Honorable Linturi approved the procurement and distribution of fake fertilizer. So for you to uphold this motion, you must be shown by way of evidence, not nice English, not high-sounding political speech that the Honorable Linturi, quote-unquote, approved. Cabinet secretaries make their approvals in writing. That's what our Constitution requires. We will be interested to be shown the approval in question. Because without that approval, then the allegation must fall on its face. We will be urging you when we get there, Chair, to ask yourself whether, as a matter of law and fact, two things, law and fact, whether the Cabinet Secretary for Agriculture or indeed any other Cabinet Secretary is allowed, as a matter of law or fact, to approve procurement decisions, whether as a matter of fact the Honorable Linturi approved or in any other way engaged in any act or omission that can warrant the accusation that he approved the procurement of fake fertilizer. When we get there, Chair, we'll urge you to read document number 3 in our bundle, and document number 10, and document number 21 in our bundle. And we'll be urging you to check and to find that when you read those documents, one, it is clear that the NCPB is a semi-autonomous government agency with its own board, with its own bureaucracy that is legally and factually immunized from ministerial control of the type that is alleged before you. We invite you to note, because the allegation is one of approving procurement of fake fertilizer, we'll be inviting you to note from document number 3 and document number 10 and document number 21 that there was no tender document for procurement of fake fertilizer. On the contrary, on the record before you, the procurement in question was, quote-unquote, to procure fertilizer that meets the standards set by the Kenya Bureau of Standards. You will note from those documents that the accused person before you even took steps, as per the document number 21, to remind that semi-autonomous government agency that they had to procure fertilizer that meets the specifications and standards set by the Kenya Bureau of Standards. Chair, this brings me to allegation number 2, which I said it is sad. We may want to wish days away. Allegation number 2 tells you that there are serious grounds for believing the Honorable Linturi has committed a crime under national law. What is the material that has been placed before you at pages 15 to 17 in support of that allegation? I mean page 15 to 17 of the motion before you. It is a list given there of court cases between the Honorable Linturi and the Honorable Member for Aldai constituency, which in the mover's own words, these are not my words, they are personal, civil, family, and commercial disputes. So it is not as Honorable Chair that I brought a matter of love, affection, and personal vendetta before you. It is ground 2 of the allegation on the record. All those 12, 15 or so cases cited there are personal disputes between the Honorable Linturi and the Honorable Member for Aldai constituency. And when we get there, the million-dollar question is, if this is not a trivial matter of love gone sour, how did the mover of the motion use material of personal family disputes as the core basis upon which an entire allegation number 2 of his motion is based? But more importantly, when we get there, Honorable Chair, we have produced before you 9 decisions of various courts, ranging from the Court of Appeal, going to the High Court, going to the magistracy, about all those so-called personal, family, and commercial disputes that form the anchorage for Ground 2. And when you read the judgments and rulings and orders we have placed in document number 11 all the way to 19, the common denominator is that the courts have ruled all those disputes in favor of the Honorable Linturi. So the million-dollar question, Honorable Chair, yes, let's assume a motion like this can be based on personal court disputes. Does it mean if someone loses court cases, they have lost at the Court of Appeal, which is the highest court on those matters, they can't go to the Supreme Court? They have lost at the High Court. They have lost at the Employment and at the Environment and Land Court. They have lost before all the magistrates of this republic, sitting in different court stations. How can it then material that the courts have ruled in favor of the Honorable Linturi form the basis for Ground 2 of the allegation before you? You have been told because, again under Ground 2, because of those family cases, the Honorable Linturi is facing an imminent arrest, imminent prosecution, and whatever. We have already placed before you a letter from DCI, of course flowing from the countless victories the courts have given Honorable Linturi, in which the DCI says they have investigated those matters and they have forwarded the file to the DPP. The DPP has reviewed all those files and advised, quote, unquote, they be closed with no further police action. So it is up to you. Who do you believe? Is it the DCI who has written, confirming, and he didn't write yesterday? It was way back last year, more than a year ago. Who do you believe? We will be submitting before you, Honorable Chair, that this mover of this motion is a proxy, and specifically a proxy of the Honorable Member for...
Chair, kindly, there are some words that we shouldn't allow to be. Let me just explain about describe somebody's case. Honorable Omanyo, say your point of order. I think we should use a language that is acceptable and not describe anyone in a manner that degrades them.
So that we don't waste time, I'm happy to withdraw the word proxy, Chair. I would also suggest when the interjection, my clock be stopped because they eat on the time. So I will rephrase, Honorable Chair, and say that the real mover of this motion before you is the Honorable Member for Aldai. We shall play before you when we get there video evidence, specifically video number 4, that confirms that. We shall invite you to look at all the cases that form the basis of ground number 2, of allegation number 2. They are all cases between the Honorable Linturi and the Honorable Member for Aldai. We will be asking you to look at page 252 on document number 10 of our battle, which will confirm to you that this allegation is actually a lie. And it confirms the DCI, the ODPP, closed all these matters with a formal recommendation for no further police action on the 31st of May last year. And then, of course, we will be asking you, Honorable Chair, when we get there, all these so-called family, criminal, civil, and family and commercial disputes, they were matters that the House considered when it approved the Honorable Linturi. Is this motion seeking to reopen a decision already the House made to the extent that it has agreed 2 of the motion? Is it seeking to reopen a matter the House considered, cases it considered, allegations it considered, and nonetheless approved? And when we get there, we'll be humbly suggesting to you, it is not possible. A cabinet secretary cannot be removed from office on account of matters that the House already considered in making the decision to approve their appointment. And while on that matter, Honorable Chair will also be telling you, all those family law disputes anyway revolve around acts and omissions that took place or allegedly took place before the appointment of the Honorable Linturi as a Cabinet Secretary. So again, the question will be asking you, does Article 152 of our Constitution provide for removal for conduct while in office, or does it provide for removal for conduct prior to assuming office? And of course, when we get there, our submission will be for matters that allegedly happened before appointment. Those are matters that belong to the committee that vetted the Honorable Linturi. And on the record, because there is a house of record, it should be clear from your answer that those matters were indeed, as a matter of fact, considered by the House. Allegation 3, Honorable Chair and members, is the one we found quite interesting. It claims the Honorable Linturi should be removed from office for 2 things. Well, they still mention the personal love issues, but 2 additional things. They say one of them is the Honorable Linturi was involved in a spat with journalists. And because he was involved in a spat with journalists, the President should dismiss him by resolution of the House. Number 2, it says, the Honorable Linturi stormed some factory and ordered it. What is interesting about this allegation is the evidence given in support of it. It is a letter supposedly authored by Senior Counsel Ahmed Nasir Abdullahis and a press statement. I repeat, Honorable Chair, a press statement. That's the evidence. Not by the journalist supposedly assaulted by the Honorable Linturi, but by the President of the Law Society of Kenya, who is not a journalist, who does not claim to have been present at the time when the so-called spat occurred, and will be trying to tell you it is all hearsay on the back of hearsay, and when we get there, we'll be, of course, telling you why hearsay cannot justify the making of allegations such as the ones before you. When we get there, Honorable Chair, we'll be asking you, can a resolution under Article 152 be approved on account of acts and omissions of third parties? In this case, the acts and omissions of the government bureaucrats at the NCPB. Or must there be an excess, as we were told by the Supreme Court? We have attached, we will urge you when we get there to look.
Order by Honorable Manu.
The Council for CS Linturi has mentioned quite in an extensive way about ex-wives and all that. I think it must have left the video. If that ex-wife is alive and can help people who can also talk for themselves, it's fair.
We'll get there, Honorable Chair.
Council, you can proceed.
The ex-wife is very much alive. Maybe I do conduct ladies, I do talk to ladies in the evening. I talked to her last night. She's very much alive. After reading the response that had been filed in the court, I said to her that, look, I understand you had one child with Honorable Linturi. He said, no, have you? I never had a child with that person.
Senior counsel, you did your part, but you have given us a good break of laughter.
The way all this is eating into my time, how that will be calibrated accordingly. But Chair, I was about to tell you that the person I have come to represent here is a man who has held many state offices in which he has served with honor and distinction. We have particularize that in paragraph 2 of our affidavit. The man I represent, contrary now to the calumny writ large in our press and other forums.
I'm talking to you, Rish. Welcome here. I'm really humble, so ni gift gani hujaipata kwa hii life?
Not by himself, not by his ministry, but indeed by independent agencies of state that are not under control.
You are gifting a man. Nasikia secretary akikwambia wacha niangalie ile gift expensive. Namsikia. I talked to her yesterday and she was so cool. Like alikuwa ananiambia, "Oh, my boss anaongea na mtu fulani." Namwambia, "Okay, I'm trying to call him but he's a bit busy. Do you mind? I'm in Ethiopia. I'm coming today."
So yeah. Such an institution,
do you mind if I talk to him? Akanambia, whenever I'm free, I'll connect you to him.
Secretary for Agriculture.
Now, by the way, I was there.
For something.
I remember. I would hear you talking.
Entirely.
But I fear something.
The man I've come to represent here, Honorable Chair, unfortunately, has been the victim between 2018 and 2022 for a 5-year period of a state-sponsored public shaming, public vilification, public defamation campaign. We are mentioning this, Chair, because as human beings, there is a tendency sometimes to say, it is that bad guy again. The Honorable Linturi, of course, as you'll find in his response about this issue, is that this campaign was sponsored by the previous administration, issue of family disputes, so that at every TV broadcast for those 5 years, at every possible newspaper headline, at every possible FM radio show, it was always Linturi the bad guy. And specifically, I represent a man who has been painted to the world as an incorrigible womanizer, criminal, fraudster, thug, scoundrel. You can call it whatever. I represent a man who, unfortunately, for lack of a better word, Honorable Chair, is the dog that has been given a bad name. But we must tell the move of this motion, we don't dismiss people from state office because they have a bad reputation, especially when that reputation is an artificial creation of a previous administration that was only doing this to punish the Honorable Linturi for supporting the candidature of the Honorable William Ruto as President of the Republic of Kenya, as opposed to the other candidature that the administration then in place preferred. What I'm trying to tell you, Honorable Chair.
May I say something? May I raise an objection?
Right. I'll allow it.
Senior counsel, just a minute. Honorable Fajwa.
No, on account of his age, you can go first.
Senior counsel.
May I say, I'm most grateful to my talented friends that they acknowledge as age as being a person. Now, may I say this to my able talented friend? We must move from this culture, which was started in Kanu days, of keeping on mentioning the head of state in proceedings in order to get sympathy. appreciation and respect. His Excellency William Ruto is not a party to these proceedings. We don't have to mention his name at all, so that we impress anybody. Let us move from this culture of moving of mentioning head of state. You don't get such a thing in England where people are mentioning the Queen in the proceedings or the Prime Minister in the proceedings and so on. Nobody has done anything against Linturi because he was not friendly to the previous regime headed by His Excellency Uhuru Kenyatta, or because he is close to His Excellency William Ruto. Let us keep out and mention names of heads of state.
Thank you, Senator. So, Honorable Bajo.
Well, I think we need to be relevant. Even in open submissions, you must be relevant to the facts in issue. Those facts are fake fertilizer and the ones you call love and affliction or whatever they are. To get into politics will be getting out of the rail, and many of these members know how to play politics than people on their side. So just come back to what is relevant and prosecute your case and finish it.
Honorable Chair, I'm guided.
Thank you.
I'm guided, Honorable Chair, just for the record, I'm not saying this because it is irrelevant. Every legal dispute has a context in which it arises. And if you just allow me to finish, it will be clear why I'm mentioning this. And specifically so that we don't waste more time. All I'm trying to say, Honorable Chair, is that it is humanly possible for us to fall into the trick of saying it is that notorious Linturi. If there are serious allegations about him, they are made because they are true. And that's the only danger that I'm warning the committee about. That is the only context in which I tell you, because it is public knowledge, that the man I represent was a victim of that public shaming, public vilification campaign on TV, on whatever. I am here to humbly tell you, Honorable Chair.
I'm afraid that the member has no power to warn the committee. Yeah, that's what he said. I'm warning this committee. It is not within its power.
It's a legal term, Chair. I think my colleague, when we say warning, it's not in the ordinary sense of the word. It is in the sense used to direct juries about the dangers of prejudice and the dangers of bias. So it is not a warning, of course. Honorable Linturi has no capacity to warn anyone.
Thank you. Thank you. Thank you.
It's a term of art and it's a legal term. I think my colleague doesn't know.
Thank you. You have educated those who are jealous, and we have.
May I say something? Let us not forget. With a serious tone. Let us not forget. He has told this select committee that he banned relevant. So when he uses the word war, he knows what he's talking about.
Thank you. The honorable members are here.
Honorable Chair, with all the interjections now, I don't know how much of my time has been spent in the. I will ask.
We will take care of
Okay,
that.
okay.
We will take care of that.
Okay.
We have taken note of what you have said. Thank you.
Much obliged. So, Chair, I was saying that when you sit as a judge, because this committee is sitting as judges, the practice in the legal world, and luckily there are many legal minds in your committee, is always to one of the dangers of putting in your mind, oh, he's that bad guy. And because he's that bad guy, he must be guilty. The allegations must be true. That's all I'm doing by giving you that context. And I must also tell you, Honorable Chair, we must be dangers of the crucify aim approach to a matter like the one before you. In the Christian Gospels we were told, because the mobs were baying for blood, crucify him, crucify him. He's a bad guy, therefore, and I'm saying again, it is easy for you to be told cries of farmers, cries of victims. And of course, we are not here to trivialize. Farmers have suffered in this matter. No one can deny that it is treacherous. What happened is as unfortunate as it can get. But that would not justify a lynching or a crucifying him. The Constitution chair, you are to investigate. Your duty is not just to roll heads, to serve somebody's head in a platter so that the masses can stop saying crucify him. We are baying for blood. Honorable Chair.
Let us be honest. Let us not waste the time of the committee. We are doing so, I'm sorry. Linturi himself has said very loudly that the farmers who received this fake fertilizer will be compensated. He has said so very loudly.
Honorable Chair, I will seek your protection because I now believe there is a strategy to interject so that my thoughts don't flow. I never thought when they were talking. For a whole 40 minutes, there were many things they said that I had issues with.
Council, we are aware of all this, and Senior Council, you had your time, and if we keep interjecting, then you will interfere with this time. We are already, we will add some more time as a result of what we are doing. Kindly be patient because you have 40 minutes.
Thank you very much, but only one sentence.
Yes.
He did not interject because we were talking sense.
Because when you're also raising the issues, we kept quiet. Because I remember at one point, the mover got to perfect minister. I know. I am not. I am best.
Honorable Chair, and I'm saying debates the use of basically, all I'm saying is that this matter is not one which in which we can the speaker said these proceedings are characterized by 10 degrees of seriousness, fairness, transparency, and this committee is sitting in your capacity as
And I wonder why we are getting and make conclusions, and we were very fair with Honorable Wamboka and his team. So I don't see why we should, always...
Fanya kenye unataka sasa, nimeamua. Mimi ni watu wengi bwana. Fanya kenye unataka kunigonga. Siwezi kuwa mjinga hivyo. Mbona unataka kunipeleka shule?
Thank you, Chair. I was to say you sit in this committee as just...
Pengine huyu ni mwizi mwenzako wako na yeye.
Usituite wewe. Na usishike simu yangu hivyo.
Nipe message.
Hii simu unashika hivyo vile unashika upasue.
Niko na simu brother, usifikirie
This is human beings.
nipe simu. Hata kama nikupasue
It is
utapasua.
only
Nipe
the
simu.
series of
Utanunua. Haivibani. Nipe message. Nipe message. Nipe message.
another human being.
Nipe message.
The other thing
Unaidi message nikiona na macho. Alafu niambia ati uko sawa sasa, pengine umetuma. Nipe hiyo umetuma vizuri nione niende period.
because it elevates the human being making that decision to the level of God. That is why our constitution in the third schedule, the Honorable Chair says, justice is to be administered, quote unquote, without any fear, favor, affection, bias, ill will, prejudice, or any political, religious, or other
Sikupi aloili.
among
Kwani kwa hiyo gari kuna mtu anaitwa jina Brian.
Unalipa na hii brother.
Hii simu yangu sikupi.
that oath of office for judges
Ukisikia kulipeleka
is the
sasa kulipeleka.
applicable constitutional threshold for resolving the matter before you. I'm here to tell the Honorable Chair and Honorable Members that justice is a two-sided coin. A coin has...
Fanya kenye unataka sasa, nimeamua.
There must be justice for farmers, but there must also be justice for the Honorable Linturi. An injustice to Honorable Linturi cannot be justice to farmers. Just like an injustice to farmers cannot be justice to Honorable Linturi. And your duty as a select committee, therefore, is to inquire into this matter using that constitutional threshold that I've just alluded to, and to decide this matter as judges without fear, favor, and all those other things that I mentioned. When you see the motion before you, there is not a single act by Linturi, there is not a single act or omission disclosed on his part. On the contrary, what is before you are alleged acts of third parties. We have placed before you in document number 2 and in document number 21 evidence that shows that Linturi is not guilty of these allegations. We are here to tell you, when we get there, Honorable Chair, that this motion seeks to punish a single CS for what is the official policy of the government of Kenya. The fertilizer subsidy program is officially part of the program of the Kenya Kwanza government. The motion itself concedes this, and in fact it states in black and white that this program, this policy, was part of the Kenya Kwanza manifesto, and it was even put to the voters in the election. How is it, therefore, Honorable Chair, that if those are the facts as pleaded by the mover, we now isolate one cabinet secretary for what is considered in the motion to be part of the official government policy, and say this is the cabinet secretary who is liable for whatever went wrong with this policy? We will be asking you to check that the whole of ground 2, as I said, is matters that predate the appointment. We'll be urging you, when we get there, to note that the mover has lied. L-I-E, Honorable Chair. They have misrepresented one of the many family and commercial and whatever disputes in which he tells you that the Honorable Justice Omundi condemned Linturi and found him guilty of some things here and there. On the contrary, because we have produced that document before you, that judgment, we will invite you to read it. It is, I believe, at page 228 of our Badu, to ask yourself, is it true? And are we going to believe a mover who has the audacity to even lie to you on a document that is in the motion in black and white? He tells you this is what the judge decided. It's there. That's not what the judge decided. On the contrary, that ruling upheld the complaint that the Honorable Linturi addressed about the persecution by the previous administration, about the previous administration latching on to personal, family law and love matters to convert them into a tool for negative media campaigns, as a tool for criminal arrest, as a tool for other forms of state-sponsored oppression. We will invite you to note at page 252, document number 10, that the matters were closed, as I told you. We will invite you through documents number 11 to 19, as I said, to note the courts, and I mentioned them, all of them, sitting in various stations, ruled in favor of Linturi. How can that material now, in which the courts ruled in favor of the Honorable Linturi, be the reason we are here? And lastly, Chair, so that I'll give my waiter at least 10 minutes, I want to come back to judging, because you're sitting here as judges, and I said judging is the only human enterprise where human beings take the seat of God and pass verdict on whether the behavior of other human beings is sinful, is criminal, is moral or immoral, and whatnot. And because it is something where we take the position of God by passing judgment, I am to reflect and ask myself, what does God teach us? Unfortunately, I'm not a religious man, and my interaction with religious texts, Honorable Chair, is sporadic and disjointed. But I tried the most I can to ask myself, what does, if we agree that judging, which is what you're doing, is the only activity in which we take the place of God? And I ask myself, from Islam, what do we learn? Because the dominant religions in Kenya are Islam and Christianity. In Islam, I checked one of the hadiths, Hadith 3566. The hadiths, Honorable Chair, are recordings of conversations the Holy Prophet is believed to have had with various actors and passed on the divine revelations to him. So this particular hadith is about judging, and it says, if I may read, judges are of 3 types, one of whom will go to paradise and 2 to hell. The one who will go to paradise is a man who knows what is right and gives judgment accordingly. But a man who knows what is right and acts tyrannically in his judgment will go to hell. And a man who gives judgment for people when he is ignorant will go to hell. It's book 24 from, I think, Hadith 3566. You know, Chair, when I say you're acting in the place of God, because that's what the law permits you to do, if you doubt that you're actually in the place of God, the decision you make, there is no legal recourse against it, just like judgments passed by God. You know, the other judgments, we go in the lower courts and whatnot, you can appeal to the High Court, appeal to the Court of Appeal, appeal all the way to the Supreme Court. Yes.
I need to notify you that you have less than 9 minutes now, together with the time that you have allocated. You have added 5 more minutes because of the interruption.
Can I assume you will allow my friend the 10 minutes I had craved for? Unfortunately, all the interjections now sort of mumbled down.
Mimi naweza waacha wakati wowote. Nimeishi maisha nzuri. Nimetoa kila kitu kwa mwili yangu ilikuwa. Sasa hii ndio nimenunulia nyumba. Ni 50 by 100. Watoto si wako 23. Kila mtoto na watoto wawili 50 by 100 moja. Hii inaitwa Prime. Konza Prime. Juu hawa watoto wakikuwa wakubwa ndio watafanya kazi pale Konza City. Unaona Konza City? The city of the future. Nikasema niwanunulie hapa karibu na Konza City. Ile iko juu ni Serene, lakini nataka chukue hii Prime. Huyu ni mtoto yangu.
I wonder.
Mama nyama.
to
You
move this
mapua.
motion
Okay,
when as he
sawa.
was prosecuting
Haina
his own
shida.
spouse was defending
Nikita jina yako
in
unaenda
criminal
nasimama kwa land ya
proceedings for fraud.
Obongita. Enda
With those very
pale.
many remarks, Chair, please allow me to
Abskondita.
call
Enda
Mr.
pale.
Mawira. And thank you very
Absko.
much for the
Sakai.
time.
Enda kwa muti upande. Sakayo. Soka.
Honorable Chair and the members, my name is Boniface Mawira. I will begin from what my learned senior Dr. Muthomi was alluding to, the issue of the judgment that the mover or the sponsor of this motion has referred to in allegation number 2. All these issues about love and affection. It is very unfortunate that as the Cabinet Secretary has to respond to these allegations, because from where we sit, they are really belittling of this committee, that this committee has to descend to that arena of love and affection. But because the Cabinet Secretary must respond, then we are compelled, Honorable Chair, to bring to your attention that there are 3 judgments, a judgment and 2 rulings. There are 3 judicial decisions by the courts of this republic that in all the 3 judgments, the courts, judges are found in favor of Honorable Linturi that all these allegations of uttering false documents, procuring execution of documents through false pretenses, allegations of forgery and fraud. These 3 different courts sitting in different stations in the Republic are found in his favor. And they have held in the judgment of 30th November that the mover has referred to in his motion, specifically ground 2, that the allegations of forgery, the allegations of uttering false documents, procuring false execution of documents, all those allegations are untrue. And that is why we say, Honorable Chair and the members, that the mover has seriously mischaracterized the judgment of 30th of November 2021, which we have referred to in our response. Even more importantly, Honorable Chair, you will note that ground 1E, allegation 1E in the motion, it talks about alleged gross violation of Article 152 of the Article 152(5) to 10 of the Constitution. We submit in response, Honorable Chair, that those provisions of the Constitution are incapable of breach by a Cabinet Secretary. There is no duty imposed in law on the Cabinet Secretary by Article 152 of the Constitution. Article 152 of the Constitution merely talks about the powers of the President to appoint a Cabinet Secretary, and even the powers of this committee, or even the National Assembly at large, to dismiss in the event that a motion calling for the dismissal of our Cabinet Secretary is upheld. So there is no specific duty imposed in law for the Cabinet Secretary under that constitutional provision. So it must therefore be that that constitutional provision is incapable of breach by the Cabinet Secretary. Honorable Chair, all the judgments that have been that are referred to in the motion under allegation number 2 about serious reasons to believe that the CS has committed a crime under national and international law, all those judgments that relate to this love and affection, all these judgments and all these matters that are referred to, all those court cases, they predate his appointment as CS. These are matters that were disclosed to the Committee on Appointments during the vetting of the CS. And these are matters, therefore, that could not have arisen as a result of the performance or the execution of the duties of the CS. These are matters that were there before, and the Committee on Appointments considered them in approving his nomination. Honorable Chair, my learned senior Dr. Hamino, in his opening statement, talked about the Evidence Act and the place of the Evidence Act in these proceedings. It is important that I make this clarification in order to not only to guide the committee, because we have made, in our response, in our response, Honorable Chair, there are documents that the mover in his motion has referred to, which we contend are inadmissible hearsay. And this committee, Honorable Chair, you will note, adopted rules on the 2nd of May of this year in its first sitting. And rule number 14 of those rules, Honorable Chair, says expressly that these rules shall complement the provisions of the Evidence Act. So it is not true, and in fact it is misleading for my learned senior to say that the provisions of the Evidence Act, specifically on the issue of inadmissible hearsay evidence, do not apply. This committee, in adopting its own rules, clarified and stated expressly that the provisions of the Evidence Act apply, and these rules merely complement, that is the language of the rules, they merely complement the Evidence Act. And therefore, it must be that those rules, especially on the admissibility of hearsay evidence, they must apply to these proceedings, Honorable Chair. There's another allegation, Honorable Chair, that the mover in his opening statement alluded to about Ugandan farmers sourcing and actually buying fertilizer. That is clearly meant for the Kenyan farmers. The subsidy program, Honorable Chair, you will note, for a farmer to be able to purchase fertilizer, they need to register on the Kenya Integrated Agriculture Management Information System, KIAMI system. And more than 4 million farmers have registered on that system. And the principal document for a farmer to be registered on the system is the ID card. So how is it possible then for a Ugandan farmer who is not Kenyan to acquire this fertilizer if they are not on the system? Because for you to get the fertilizer, you need to be registered on the system. Even more importantly, there is an e-voucher that is sent to your mobile phone number. So the ID is a principal document. And Ugandan farmers clearly do not have Kenyan ID cards. Honorable Chair, I think the last point for me is on the issue of evidential threshold, as my learned senior Dr. Muthomi alluded to. The Sonko case is clear that when it comes to matters of admissibility of evidence, inadmissible hearsay evidence would clearly fall short of the evidential threshold and the nexus that the Supreme Court stated is required before a resolution for removal of a state officer from office. And, Honorable Chair, I would just want this Honorable Committee to take note that let the committee, because we have had in other proceedings elsewhere, before the Senate, and specifically when the Senate was debating the impeachment bill that is currently before Senate, I personally had the majority leader of the Senate say that that bill is meant to cure or to remedy the problems that arose after Governor Sonko was unlawfully handed out of office. So let us not, Honorable Chair, fall for that mistake. My last point for me, Honorable Chair, is what my learned senior, and as we've been saying, the Honorable Member for Waldai is the real face behind this impeachment motion. And as my learned senior confirmed, he even met her yesterday evening. He met her yesterday evening and she was telling him she does not even have a child with the Honorable C.S. Linturi. Clear, what would be the motive for the council representing the sponsor to meet her if she is not the real face behind the motion? And the entire ground two, all those allegations that point to these personal, family, civil, commercial disputes are between the CS and the member for Waldai constituency. So clearly she is the face behind this motion. And that is why we are saying this motion is actuated by malice and personal vendetta. Honorable
Manuel, please let us continue because it's just about to conclude. I want to protect
the lady in question. We are talking about Linturi, not the ex.
Thank you.
It is.
The matter was brought by the sponsor of the motion.
Thank you, Honorable Chair, for the protection. Honorable Chair, my last point for me is let us do justice. As my senior said, justice is a two-sided coin. And injustice to Linturi does not mean justice to the farmers. Justice for the farmers does not mean injustice to Linturi. Let justice be done to either party. And the CA sympathizes with the plight of Kenyan farmers. The farmers who are duped, they have suffered enough. But let justice be done for both parties. Thank you, Honorable Chair, and the Honorable Committee for listening to me.
Thank you for
Chairman, I don't know whether you will allow me one.
keeping time. Yes, 1 minute I will allow you.
Chairman, let me respectfully make a comment. I'm really not going to linger so much on what my friends are saying. Just want to mention the members of
Honorable Minister, Cabinet Minister, please go in front and use the
Chair, as he's going there, on a light note, CS Linturi is the chairperson. It is not chairman because our chair is the lady.
Chairman, on a point of order, Chair. Chairman is a position. Can be a lady. And I'll tell you, there's a lady who was elected the chair of the Doreen Club. And she said, I will be called the chairman. That was Dr. Professor Yeko. And she remained as the, it doesn't have a gender orientation. But she said on the light note.
I know man stands for God, but please, because of time, let us allow the Cabinet Minister to continue.
Thank you, Chair. And Chair, let me appreciate what the committee is doing, because that's a constitutional responsibility to discharge. But I've inclined, just been felt that I must really say something, because Chair, whatever I've gone through for a number of years, and which is also manifesting itself here, is not anything I would want to wish any human being. It has been a long journey, very painful, and when I thought I'd gone through that kind of trauma, the motion is here with the same stories that I've been trying to fight over years. When Learned Council, Camino, tries to trivialize this matter, it pains me because it doesn't know how painful it is. Because, Chairman, there is no, in the history of the judicial system, nowhere, and this matter has ever been done or conducted live on TV. It was mine. And that was the reason when Dr. Mithika Linturi's tries to contextualize this story, then it's not taken seriously. Just like as mentioned, there's a judgment there by Ongundi, which clearly in a paragraph says that is what happened. When counsel for the mover accepts in before this committee that was called, was having a discussion with the so-called, with the person that we are referring to as a proxy, one wonders what is it that was being discussed. So, members of this committee, I would want to say one time that as we look into this matter, let us really look at the matter on the basis of evidence and the fact. I am ready to defend myself, and I really know the pain that the number of farmers that and already interacted with the few bags of fertilizer, I really feel for them. And I've taken corrective measures from the ministry. Those people that we believe were culpable, I've already taken plea. And Chairman, I want to leave it at that, but it's very painful for me because when I took over the ministry, the country was in a crisis, didn't have food, we were trying to import food. We've produced 67 million bags within the first year. And when we are telling people going back to the farms, I thank the farmers that came to listen to us. I was shown Jahon, and because this is what I would call occupational hazard, because it comes with the job I'm doing. But remember, members, I sat on that side for 15 years. You may also cross to this side. So as you decide on this matter, please note do injustice. Thank you so much.
Thank you very much. Members, we are done with opening statements from both the parties. Now we will proceed to evidence taking. Honorable Jack Wanami Wamboka, Member of Parliament for Bumula constituency, you have 4 hours. And I ask the clerk now to administer the oath because you are the first witness.
I'm sure you need a break or break.
Members are in agreement 10 minutes, yes, and then we resume. Thank you.